Okay, I'll put the recording on, and this recording subsequently will be shared online. Don't worry. Before I begin, I just want to say something. It's about the disclaimers for this class. As you all know, LPQB do not endorse any official answer, or how to say, they provide any reference to our students or any college about the format of the answers that should be given. So this teaching is entirely on my personal opinion. To be frank, this is personal opinion about how you should approach this professional paper. Okay. We'll go to the first question. Some of you may join my class before. Normally, what I did is I will read all the question, and then I will also give my suggested answer. And at the end of the day, what I'll do is I'll invite you for discussion if you do not have, if you do have any questions. Okay. So this is the first question of the day. Norman, an advocate and solicitor, acted for plaintiff Sulaiman in a defamation proceeding against the defendant Mutu Sami, a wealthy businessman turned politician. The hearing was scheduled to take place before Ong Justice, but due to a transfer, the matter was fixed to be heard before Abu Bakr Justice. So what happened next? Norman immediately filed an application to recuse Abu Bakr Justice, as he has previously read a blog which alleged that Mutusami and Abu Bakr Justice were seen holidaying together in Hawaii, and Abu Bakr's wife works in the foundation set up by Mutusami. Norman did not consult the plaintiff. So who is the plaintiff here? Obviously, from the text given, this is referring to Sulaiman. He has, before the filing of application, published in his own blog a copy of the cost papers. Cost papers means probably include the notice of application and also the affidavit in support. So he published online. Okay. Relating to the application for recusal under the caption diabolical scoundrel. Okay, so he accused this Abu Bakr Justice that he's not acting correctly. Okay, he also stated in great detail the reasons why the recusal must be sustained. He ended the blog entry with the words that only a retard will continue to stay. When the matter came up for hearing for the applications for a recusal, the following exchanges took place between Abu Bakr, the judge, and also Norman, the solicitor for the plaintiff. So the conversation goes in such a way. Okay, Abu Bakr Justice asks, are you authorized by your client to file this application? Norman replied, the application has been filed. Why bother? Please recuse. So the tone, it seems to be quite a hostile one. Okay. Abu Bakr Justice replied, counsel, please answer the question. And Norman said again, that question is irrelevant to the application. So Abu Bakr, you see or not, there had been exchanged words between the parties, someone with the judge. Okay, Abu Bakr Justice try to calm Norman down. Compose yourself. The question is relevant, and may I have a reply? So Norman replied, your lordship must have a hearing issue, or is the problem far deep-rooted and has traveled from the ear to the brain? Retarded scoundrel. Okay. So this is basically is not correct already. So Abu Bakr said, counsel, may I remind you to conduct yourself with decorum. Please be polite lah. Okay. So Norman then reacted heavily. He slammed the brief on the table and quickly left the courtroom and uttered, I will take my case to the court of public opinion. That is to say, he's going to put something on his blog online again. So Suleiman, as the client, was very shocked to witness the whole incident and confronted Norman, who stated, I'm a barrister, and immunity applies against negligence, number one, and I am immune from contempt of court. Okay. The task given to you here is to advise Sulaiman as the client. Okay. Question 1A. With reference to the relevant legal provisions and decided case, what amounts to contempt of court and what are the types of contempt of court? Okay. Basically, they ask you to define and classify the types of contempt of court. This sort of question given to you is 10 marks, isn't it? So you have to display some degree of wide reading, you know. You cannot simply write something very superficial. In such a way, I mean, if you do perform in such a way, just write briefly about what is the contempt of court. I afraid the marks given to you will be quite poor. Maybe they'll just give you 4 out of 10 marks. Ngam ngam lulus, this kind of mark. You must read a lot and you must keep some, famous judge say case law, etc. to meet the satisfactory answer. Okay, first and foremost, I will straight away begin. This is my suggested answer. And just be reminded, my answer will be a little bit long because it is meant for your revision. But during examination, I don't advise you to give a lengthy question. Particularly, do not just focus on one question. You write 3-4 page just for question one, neglecting the rest of the question. That means to say all 5 questions, you must do your time management well. Okay. So my suggested answer is like this. The contempt itself, you cannot find anywhere, You cannot find any statute that define contempt. So this is based on common law principle. And I quote one judge, Justice Loh Hock Bing. He said that our federal constitution, acts or parliament, or other written laws do not actually define the contempt of. Okay, it is a common law phenomenon. Okay, then subsequently you can use the case of Attorney General against Manjit Singh Dhillon. Manjit Singh Dhillon was actually the previous president of Malaysian Bar. You see a few fellows that committed contempt of court, like Arthur Lee, Kumarendran, all that now. They are actually very high profile lawyers, Then only they dare to challenge the judge. You get what I mean? Okay. So in reference to this particular Manjit Singh case, the Lord actually quote the statement from R against Gray, saying that contempt of court is any act. So it refers to any action, tingkah laku, or any writing published. Okay, that means to say any comments, whether you give to the newspaper, you publish online, or even you write a letter to the court that actually amount to interference of justice, okay, or lawful process will be called contempt. Okay, so what is the objective to have this sort of contempt of court? That means to say, I'm trying to ask one question. Is court so sensitive up to the point you cannot criticize at all? Is that the whole purpose? Okay. Actually, contempt of court is just to prevent any interference. Gangguan, It's just to prevent any obstruction of justice. thereby ensuring the confidence of the public in the administration of justice. Once upon a time, actually 1999, during that year, okay, Malaysian Bar had actually proposed the Contempt of Court Act 1999, which is a little bit peri material with Contempt of Courts Act 1971. That law is actually passed in India, but Malaysia never accept the proposal of Malaysian Bar. Okay, and generally speaking, you can see, okay, contempt of court, we have two types. That is civil contempt and criminal contempt. And this is the time where you to describe using the case law that you have learned. I use one case here, Datuk Sri Sami Value against Penerbitan Sahabat. This case is related to a defamation case and also a malicious falsehood case in which one Tamil newspaper is trying to defame the ex-MIC president. Okay. So contempt of court, in this particular case, they classify as 1 to 5 above, below. Disrupting the proceeding of the court. Second, publication of proceeding. Third, publications of proceeding that amount to scandalizing the court. Just now is to interfere the proceeding itself. And fourth, disobeying the court orders. And finally, failure to take to fulfill undertakings given to the court. Okay. The first three are actually called criminal contempt. Okay. And the fourth and the fifth one are actually civil contempt. Okay. But nevertheless, even though there are common law principles that try to distinguish civil and also criminal contempt, but there are cases say that the distinction between the two or the classification between the two are actually meaningless because eventually it's still under the umbrella of contempt of court. Okay. So civil contempt and criminal contempt, how do you further elaborate? Okay, like this Datuk Sri Sami Value case had suggested, this civil contempt actually said that you don't obey the court order. That means whenever you have a judgment or any sort of order, perintah from the court, as the defendant or as the losing party of this civil suit, you don't obey it. Okay, take for example, there is an injunction order. You purposely infringe the order in terms. What happened is people can cite you for contempt of court by committal proceeding. Okay, this is how, okay. So in this particular case of Q Shi Kian against Red Rose Restaurant, okay, for you to amount to a civil contempt, number one, priority, you must have a court order. Okay, that one is very obvious. You must have a court order. Secondly, you must have a penal notice. We call this penal notice is that at the end of our print, we'll put one endorsement. If you don't follow the court order, we will cite you for committal proceeding. This is what we call penal notice. Second criteria. And the third, the proof of the breach, the standard for this breach is beyond reasonable doubt. This one also very important. Both civil and also criminal contempt apply the beyond reasonable doubt principles. Okay. And in one case here, federal court, T.O. Thomas against Asia Fishing Industry, mens rea in civil contempt, even though we use the beyond reasonable doubt principle, but mens rea is not important. Okay, and come to the criminal contempt. So what makes the court wanted to do criminal contempt in the mischief behavior of a witness or a lawyer? They will use criminal contempt is that they can punish the contemptor instantaneously. They can immediately, okay, like in this case, Norman case, isn't it? They can immediately ask the lawyer to explain why you behave like that. If the lawyer fail to give a good explanation to the court why he behave like that, he will get punishment on the spot. So this is criminal contempt. Whereas civil contempt, you have to get leave of the court and by way of notice of application supported by affidavit. This is the difference. Can you understand so far? So far can you understand? Or am I going just too fast? Okay, that's good. Okay. So we have several types of criminal contempt. So criminal contempt can be in facie. You must use some words to impress your examiners because they are the types the senior lawyers. So usually they want to see some answer which can differentiate you from average student. There are two types of criminal contempt that are in facie and ex facie. In facie means in the face of court. Okay, in the face of court normally happen inside the boundary of the room. Like in these particular examples, Norman, when he tried to exchange words, it's not just exchange words. Basically, he's just insulting the Brubaker judge, isn't it? This is already a type of contempt in facie. Okay, you can use a few example like Karam Singh, uh, Kumarendran, Cyrilan, okay, for example. These are the types that exchange words with the judge. And another case that worth your attention is Matthias Chang's case. Matthias here is actually being a witness. He himself is a lawyer, but he acts as a witness of one case. In this particular case, he tried to teach the judge the law, and he's very unhappy with his so-called bias. So what he did is he quarreled with the judge and walked out from the witness box during cross-examination. This sort of case, you must familiarize with in order for you to score. Asphyxia means contempt out of the courtroom. Ah, this one, it refers mostly to the publication. Okay, of course, you can publish some material that about your comment about a case. It is allowed, but don't go and scandalize the court. Don't go and the judge for, using the deciding wrongly, having bias, you know, all kind of thing will amount to sub judice rules. Okay. So scandalizing cannot, okay, and sub judice rule. Okay. Sub judice rule means what? During the pending ongoing of the case, you try to use the media or press power to give pressure to the court to decide a case in favor of you. Take for example, there's a murder case. You know that um, there's the flaw of the investigation. You go and release the news to the Sintiu or Utusan Malaysia so that the journalists can write a big article about the flaws to influence the decision of the judge. This one cannot. Okay, you can cite the case of Murray Hibbert here. Okay, after you have tell all this, you must come back to the question itself. Because your position here is to advise Sulaiman about what to do, isn't it? So you have to relate the facts and also the law. Okay. You see, what Norman did, number one, is that he filed a recusal application without consulting Sulaiman. Okay. Is it right or wrong? Actually cannot. By right, in a civil suit, or even if it is a criminal suit, whatever application that we file, number one, we must acknowledge it to the client and get his or her consent. That one is very important. Okay. And second thing, what Norman did is verbal exchanges during the hearing. This had already constitute a contempt in the face of king. Okay, in facie contempt. Okay. And slamming the brief and leaving the room, all that is also a type of in facie contempt. And subsequently, what Norman claimed that he's immune from contempt of court is entirely not true. Okay. You can cite the case PP against Sierra and also Matthias Chang's case. Okay. But at the end of the day, you must also come back to the question, what Sulaiman's will be probably curious about this incident. As a client, number one thing that you're curious is whether your case will get thrown out by the court or not. Correct or not? Because you want to win the case, ma. Your lawyer already behaved in such a like a monkey in the court. So uh, probably as a prudent and reasonable client, you want to ask this sort of behavior, is it a personal action by Norman or will it affect my case? The answer is yes and also no. Because the judge is the one that decide your case, isn't it? So if you, okay, contempt of court, no doubt is Norman's personal action. But I will propose Sulaiman to reconsider his legal representation. No doubt this is a personal action, but at the end of the day, because the lawyer is not giving you a pin that he's trying to file something, so this already, breach the trust relationship between solicitor and also the client. So what I will ask Sulaiman to do is, as an advice, he should seek to change his lawyer. Okay, that is number one. And number two is he may also consider filing a complaint to Bar Council regarding to Norman's conduct. Okay, conduct as of what? Filing application without his knowing and also behaving rudely in the room. Okay, this will be the complete answer. Okay. Second question, question B. Discuss the scope and extent of the power of the court to punish for contempt. Okay. This one, they ask you to discuss about the laws. So you must be specific in what laws to be cited. You must cite the correct provision, otherwise they wouldn't give you marks also. Okay. The first power, the very, very original power to punish contempt of court for superior courts actually coming from Federal Constitution, Article 126, which provide all the superior courts in Malaysia, namely High Court, Court of Appeal, and also Federal Court, have the power to punish for contempt. The same is being repeated in Section 13, Court of Judicature Act. This CJA is actually used for the superior courts. Okay? And also Section 99A of Subordinate Courts Act 1948. Okay? That means to say magistrate and also session court also can punish contempt. Okay, this is provided under Section 9 of third schedules, SCA 1948. Okay. And one more thing, as we have previously discussed in question 1A, you know there are two types of contempt of court. So one more power, is actually provided under Order 52, Rules of Court. That is to punish committal proceeding. Okay? And basically, if we talk about superior courts, their power is without boundary. That means to say there is no maximum sentence for contempt of court. They can fine you 100,000 ringgit. They can sentence you to 6 months imprisonment. Also can. Or they can do both on you. So there's no, how to say, structure guidelines for the court to impose the contemptors with so-called punishment. Okay? But however, this is not the case in a magistrate and session court, whereby Section 26 schedule of SCA 1948 provides that session court can only fine up to 300 ringgit or imprisonment for 6 weeks. In the case of magistrate, now we do not have first class and second class lah. Okay, so we look at this as all first class magistrate, a fine of 150 ringgit or imprisonment up to 3 weeks. Okay, so these are the what we call the power given to it. And this is just I copy and cut from the SCA for the purpose of your reference. Okay, so committal proceeding, the judgment, I mean the punishment that can be given, up to imprisonment up to 6 months. Okay, and as a summary, to define the extent and also the scope of contempt of court, so the court can actually punish a contemptor with fines, imprisonment, and one more thing, don't forget, if it is a committal proceeding in the civil case, you can force the party to do certain things, like sequestration of assets or even equitable relief, like injunction. You can warn the so-called the default party and force them not to go nearby, usually husband and wife issue lah, not to harass the wife anymore, for example. Okay, so this is it. And question C, we talk about the negligence of advocate and solicitor in Malaysia. So this one I think is quite easy. Historical position, Ronda against Worsley. But Ronda and Worsley, you must remember one point here lah. UK system is different from Malaysia because they separate barrister or counsel work with solicitors work. Up to the point you see Saif Ali against Michelle, okay, the court will still allow immunity, for the barrister so that they can carry out their works without fear of legal repercussion. Okay, but Arthur Hall against Simon had actually removed the long-standing immunity of barrister in both civil and criminal cases. And application in Malaysia, you must be a little bit critical and you try to say that Malaysia is a fused legal profession where lawyers act as both advocates and also solicitors. Okay, therefore, you use one case, Muhammad Noor Dagang against Tuan Muhammad Yusuf Endut. This one is very important. The immunity is not totally removed. Okay, this case said that you, as a defendant, take for example, a lawyer committed some degree of negligence, you can raise a defense called limited immunity. That will be applicable. Take for example, if I am a young lawyer, take for example, if I acted for a plaintiff in a suit, whereby during the cross-examination, I do not speak as fluently as my senior counsel does. So am I negligent? At the end of the day, the plaintiff loses his case. This is not, you get what I'm trying to say? You committed some sort of degrees of fall short of the performance. Take for example, you do not ask the very important question during cross-examination, or you miss a filing lah, which is not very material to the case itself, or you miss some deadlines which just attract some objection, but the court says it's okay, you can proceed. Those type of thing will not be liable for negligence. So you can still plead for limited immunity in the case. This is based on public policy, because otherwise, as a lawyer, you will have a very, very tough time. If you do not have any immunity at all the time, your decision will be entirely based or being influenced by your client. You have to act in some degree of independence, isn't it? So this is why, as a public policy reason, the court still allow limited immunity, okay, for advocate and solicitor. I hope you are following me. Okay. We'll move to question 2. Okay. Banta, an advocate and solicitor, is acting for Maha Private Limited, the plaintiff, in its claim for an outstanding debt of 1.5 million ringgit against Tahan Sendirian Berhad. Maha Private Limited was referred to Banta by his friend Kong, who expects a referral fee. A week after the service of writ and also statement of claim on Tahan Sendirian Berhad, Gun Associates, the opponent's lawyer, wrote to Banta acknowledging receipt of the statement of claim on behalf of their client, Tahan Sendirian Berhad, but requested for 3 weeks extension of time to file appearance and defense. The reason was that the CEO of Tahan Sendirian Berhad, who has personal knowledge of this matter, was overseas. Maha Private Limited instructed Banta not to agree to any extension, not to reply Gun Associates, and to take judgment in default without any notice. Banta was earlier promised that he would be entitled to a sum equivalent to 25% of any money recovered from the defendant. Anxious to please his client and buoyed by the prospect of his own payday, upon the expiry of the time limited for appearance, Banta proceeded to file for a judgment in default. Discussed Banta's conduct with reference to the relevant rules of etiquette regulating legal practice. 20 marks. Okay. Whenever you encounter this sort of LPPER question, isn't it? My very first advice, please do. Okay, this sort of question is like a jackpot during examination. It will come out every year. All you need to do is to memorize LPPER just last minute before you enter into the examination hall. Just flip through, which is a sure question. Okay. So normally what I suggest you to do is you divide your answers according to the relevant subheading. Okay, my answer shall be tailored in accordance to the chronology of the given facts. Number 1, they talk about the referral fee. So what does it mean? I will say that this sort of referral fee probably or potentially will raise the issues of touting. Okay, then touting, you can start using your Rule 51, Rule 52, Rule 53, as well as specifically Section 94, Subrule 3, Subrule H, LPA, which said that if you procure a job or an employment through a tout, this is a form of misconduct. Okay, you'll get punishment. Okay, and Rule 61. Okay, this one also you can try to relate. Try to relate with the facts. Don't just write 61. No lay agency to control the advocate and solicitor. Full stop. This is not so acceptable in this sort of professional examination, because in order for you to get a better marks, you must relate. You try to say if Tong is trying to influence bantah action, etc., it will breach Rule 61. Okay. And second issue that I have identified is that the lack of courtesy to other colleagues, because Goon's associate had already written a letter seeking for Bantah's time permission to allow extension of time and also to file this memorandum of appearance and also the defense, isn't it? In 3 weeks' time, isn't it? So you go back and refer to Rule 18. Rule 18 said we must conduct the case with candor, courtesy, and fairness. That is to deal with our clients, the opponents, including their lawyers. Okay, you cannot do this sort of thing. And also, you must quote one Bar Council ruling, Chapter 1401, Clause 2, whereby if you receive a correspondence from our opponent or any advocate and solicitor, you must reply promptly. Okay. And third issue, Bantah's conduct had been entirely influenced by the client's instruction. So the client said, you must file JIDA fast, don't give reply to the goons, etc. So he's already influenced by the decision of the client. Okay, rather than making his own professional decision. So you refer to Rule 31 and also Rule 32. Okay, very important. So this is about this. And contingency fee. Contingency fee is 25%. Okay, that one is also not acceptable under Section 112 of Legal Profession Act. Section 112 said that you can make any agreement with your client, but not on contingency basis. Okay, so receiving 25%, just that money, like you don't take any upfront fee or what we call as basic fee. It is not allowed. Okay, and sham purchase agreement means that it's like, how to say, you take profit out of the case. Because the whole fee itself is premised on the winning fee. So therefore, it is not allowed. Okay, you can quote the case of Mokhtar Nga and Co. And one more this contract section that you can quote is also Section 24, Subrule E of Contracts Act 1950. You can say that because eventually, yes, Section 1.2 said that the agreement between solicitor and also the client is governed under Section 112 LPA, but you have your General Contracts Act to govern the operation of the contract itself. So you can use section 24E, saying that this sort of contingency fee agreement is void for contravening the public policy. And on top of that, you can use Rule 24A. Okay, you must be independent and objective when you represent the client. So if you enter into a contingency agreement with the client, largely that you will go all out to win the case. But you must remember, your paramount duty is not just to the client, you know. Your paramount duty is to the court. You are a court officer, okay? And probably if you can relate conflict of interest issue is also reasonable here, because Bantas will get some financial interest out of this case, okay? And lastly, there's another one issue that you should have highlighted. Bantas cannot enter a JIDA knowing that the defendants or their opponents is represented. You cannot do so. This will contravene Rule 56 of LPPER, as well as Bar Council ruling, Chapter 1103, whereby if you want to enter a JIDA or even a JIDD, isn't it? Knowing that the opponents is well represented, you must give the opponents 7 days. Okay, you cannot attack the opponents with surprise attack. Okay, but having said so, in a case of Sri Mina construction, it says that Rule 56 itself only govern the conduct of the advocate and solicitor. It doesn't mean the judgment in default is irregular. So that means to say, even though Bantas had eventually, he has obtained the JIDA without any preliminary notice to the opponent, the JIDA itself is still valid, recognized by the court. But only problem is Banta will attract disciplinary action. Okay. Normally, Gun and associates will complain about you lah. Okay. So what is the conclusion here? You must give rise to one sum out to what you have said, you know. So clearly, whatever we have discussed, supra, aforesaid, has suggested that Banta's action already infringed LPPR rule and subject to section 94 sub rule 3 rule B of LPA 1976. These infringement of ethical rules amount to misconduct on part of Banta. Okay. He would have been punished by advocate and solicitors disciplinary board. And to impress the examiners further, you must know that the ASDB must find Banta to be guilty on beyond reasonable doubt basis. The standard is higher than civil standard lah. Okay, so the punishment outcome for Banta could be reprimand or censure. That means warning. Number 2, fines. Number 3, suspension. And number 4, strike off. Normally in this kind of case, but I don't suggest you to give further comments. Okay, in our experience, usually this sort of case will attract warning first. Worst come to worst, warning. If you are unlucky, you meet a very strict one, probably they'll suspend you. Okay. Normally fines, they won't fine you or even strip you off. No. Struck off applicable to dishonest or fraud case. you run away with holder money, 100% you get struck off. So this is how. Okay. So very important, identify the issues, discuss under each and every subheading what you want to say. Make it very organized and systematic. Okay. Don't write your everything under the, um, like Bertrabo, That one is very, very difficult to read and difficult to mark as well. Okay. Question 3, Question 3. Celine has engaged Pandai as her advocate in an action against her former partner, Geoffrey, with respect to properties jointly acquired by them. Celine suspected that all information she disclosed to Pandai had been shared with parties. She then discharged Pandai and retained another advocate. Meanwhile, Geoffrey had subpoenaed Pandai to give evidence in the upcoming trial on the basis that Pandai is in possession of material evidence which has been disclosed to him by Celine. Celine was also informed by Pandai that in one of the case management, the judge indicated that the court may be inclined to follow defendant to start the case first. Celine is alarmed by the subpoena and the order of production and examination of witnesses and seek your advice on the following. Okay, number one, A, what is the scope of legal professional privilege? We answer this question first lah. Actually, this question, they test you on the Evidence Act, The scope of legal professional privilege is entirely governed from Section 126 to Section 129 of Evidence Act. Okay, it protects whatever, listen carefully, communications between a client and also their legal advisor. Okay, the keywords here is the communication. So whatever my client told me, whether he stole the thing, he committed the crime, he had some extramarital affairs, I cannot tell to third party, even though it is compelled by the court. I also cannot tell. This is deemed to be legal profession privilege. Okay. So what you need to do is, in your subsequent paragraph, you must try to elaborate Section 126. Okay. Section 126 actually prohibits an advocate or solicitor from disclosing any, the keyword is any, whether you assume this is confidential or not is not important, The keyword here is everything cannot disclose unless the client consents to such disclosure. Okay. You see, the client's consent itself is a strict one. It must be a written consent. It cannot just simply, okay, I allow you to tell the third party, you can discuss with my cousin about my case, like that. It's not acceptable, The consent must be a formal written one. Okay. This Section 126 has got a section, public policy reason. Okay. If the communication between the client and also the lawyers are for the purpose of furtherance of a crime or fraudulent purpose, the privilege will be waived automatically. I give you an example. Suddenly, my client, who is at the midst of divorce, tell me, look, Dr. Chi, I'm going to kill my wife on next Saturday. So you can see the communications, if I do not report this incident to the police, probably my client as a grief husband, so-called grief husband, will kill his wife. This is like in furtherance of crime already, you know. So this one, the privilege does not apply. Okay. And this sort of privilege has a long-lasting effect that even though, take for example, in this Celine's case lah, even though she has discharged Pandai, but Pandai cannot tell the so-called whatever Celine had told him during the course of employment to party, even though the so-called the engagement has been ceased to exist. Okay. And extension of what we call the legal professional privilege is applicable to those involved with the case itself, inclusive but not limited to interpreters, clerical clerks, clerks lah, or any servants of advocates like consultant lah, any other third party experts, that assist the case, they also cannot tell. Okay. And section 128 is to protect the lawyers from being compelled to disclose information in the court. Okay, so this one is section 129. Also same, legal advisors. Okay, whatever legal advice that you have given in-house or for the court purpose, you cannot tell. Okay, you cannot tell. So apply to Celine's condition. Very important because eventually you have to go back to the facts of this case. Since Celine's communication with Pandai relates to her legal dispute with Geoffrey, the information shared during their professional engagement is protected under Section 126. So during the trial process itself, no doubt Geoffrey already subpoenaed Pandai as the witness. Pandai cannot disclose to the court. So this is fall under legal professional privilege. Okay, unless Celine waived that privilege in writing lah. Okay. And so conclusion, you make a brief one. The scope of the legal professional privilege is entirely governed by Evidence Act 1950. So to ensure the whole point to have this sort of legal professional privilege is to protect the so-called trust relationship between clients and also lawyers. Otherwise, the clients most of the time the clients would think that lawyers are a very smart species of life. Okay, one of the smartest person on the earth, of the whatever professional you have across architects, doctors, accountants, lawyers will give somebody an impression you are smart plus cunning. If let's say, for example, the communication itself is not protected, no client will tell you the truth, So this is the public policy behind the act. Okay. And question B, it looks very similar with legal professional privilege, but this is not the same. Okay. Question B asks you to comment on litigation privilege. So litigation privilege itself is not under Evidence Act 1950. Okay, I will try to elaborate some examples to you later. Okay, this litigation privilege is created by common law. Since it is not being provided under Evidence Act itself, definitely common law is the foundation that support the existence of litigation privilege. It is designed to protect documents. Okay, see, just now is all the communications, okay. So this one is documents and communications that are created for the dominant purpose of litigation. Okay, whether this litigation is pending or already happened. Because you must understand, Malaysia, unlike France and other country that practice inquisitory system, okay, Malaysia is adversarial system, There is always a plaintiff and a defendant in civil case, and there is always a PP, the public prosecutor, and the accused, or KT, in the criminal case. So other party lawan, So in this adversarial system, everybody is trying their best to win the case. So there are certain documents, communications, whatsoever will form part of the winning strategy. You get me? Some of the documents are prepared, like I have discussion with my clients. So we plan striking out Order 18, Rule 19. Okay, subsequently, we must plan for the case from High Court to reduce the quantum. This is what we do. To transfer it down to the Session Court. So we jot down in our emails and then we ask for the high permission or approval from our client. So these are the things that we cannot disclose, Okay. So the key elements here, dominant purpose. Okay. You can see the case of Wolf against British Railway Boards. In this case, the expert report. Take for example, in a lot of my cases that I have handled, we have expert medical report. Until the case go to trial or near to the trial, we will not disclose this medical report to our opponent party. We need not to put this expert report in our common bundle of documents. We do not need to file it under bargain ABC at all. This one we keep to the end, you see or not? So this expert report, the other party, the opponent cannot seek to discover. They cannot under order 24 write in notice of application plus affidavit, compel us to give them the medical report. Cannot. So this one is protected under litigation privilege. Okay. So Malaysia case, you can choose one case, Wong Han Lin against HSBC. Like I have told you, internal investigation, for example, the bank one, they have forgery cases, forgery of check, take for example, they will have their internal investigation report to say that, whether the the I mean the what is that position called? On the tellers. The tellers is negligent or not. Any mistake done by the internal members of the bank, overlook this statement whatsoever. If this sort of internal investigation report are actually prepared with the dominant purpose of litigation, okay, to say that our bank is clear from errors, this one is fall under litigation privilege, and the opponent cannot compel the bank to release the internal report. Okay. So you must understand, litigation privilege somehow or other it seems to have overlap with legal professional privilege, but most of the time, legal professional privilege applies to whatever or so-called any communications that happens between the clients and also the lawyers, whereby litigation privilege only apply if the said communication or the documents are for the dominant purpose of preparing for litigation. A good example is the one that I've told you, expert reports or any internal strategies in order for you to win the case. These sort of documents cannot give to opponent. Can understand so far? Okay, that's good. Okay, question C. Okay, as you can see, this is a civil case, isn't it? So, Celine got a shock. The judge, the presiding judge, is quite inclined to the defendant's submission that they are going to start first. So the question invites you to discuss whether this is allowed or not. Okay. So this is a civil case. So what you need to do is you go back to the Order 35, Rule 4, Rule 2 of your Rules of Court. Okay, Rules of Court 2012. Okay, which talk about order of speeches and opening the case. Typically, in our setting, take for example, the plaintiff will start their case. Okay. Subsequently, starting from the first until the last witness of the plaintiff, each and every witness shall undergo examination in chief, cross-examination, and re-examination. So this is pursuant to Section 135 of Evidence Act. But somehow or rather, the court, because civil case, most of the time, the defendant in the civil case, most of the time, they will not make a so-called submission of no case to answer. They will need to call their witness at least to defend themselves, okay, or to raise some disputes, so that the balance of probability is not simply achieved easily by the plaintiff. Okay, but however, if you look at Section 135 and also Order 35, Rule 421, the court has absolute discretion to call who to come first as the witness. Sometimes it happens in such a case, plaintiff have 4 witnesses, whereby defendant has 2 witnesses. On the first day of the trial, 2 of the plaintiff witness come, and also 2 of the defendant's witness come. After finish the plaintiff witness, the court, the judge, will have the discretion to call the defendant's witness to go. To come in and give their sworn statement or their testimony. It is entirely no problem at all. Okay, so long it does not prejudice the other party. So your conclusion here, okay, you must give advice at the end of the day. So you must tell Celine that the judge has discretion to allow the defendant to start the case first. Otherwise, what is going to happen is Celine will go and object to the decision of the judge, which will, which eventually will be ridiculous to do so. This can actually happen due to a particular procedural or evidentiary considerations. Okay, take for example, if the defendant want to raise some preliminary issues that need immediate attention from the court before the plaintiff case, okay, this sort of flexibility also helps the court to process the case in a faster and expeditious manner. Because sometimes the defendant's witness cannot come, sometimes the plaintiff witness cannot come. So we try to slot in those witnesses that can be present on the day of the hearing. Okay, so it's not wrong. Question 4. Ahmad had lodged a formal complaint to disciplinary board against Hamid. After compliance of the preliminary requirements, the disciplinary board appoint a disciplinary committee to proceed to inquire into the complaint lodged against Hamid. Hamid challenged the composition and jurisdiction of the disciplinary committee. The disciplinary committee made a decision rejecting Hamid's challenge on its composition and jurisdiction. Although notified of the date of the inquiry, Hamid declined to take any further part in the inquiry before the disciplinary committee. Hamid now seeks your advice on the following. I think this question a little bit tough. I hope you don't do. I mean, this sort of question a little bit challenging, because it involves a lot of question of law. Okay. A, what recourse is open to him to challenge the decision of disciplinary committee, and whether he may apply for judicial review against the decision of the disciplinary committee. Okay. And B, they ask you what are the grounds upon which a decision of the disciplinary committee may be impunged. See, okay. First and foremost, you must try to understand how does a disciplinary hearing take place. First, the complainant will lodge a complaint to advocate and solicitor disciplinary board. Okay, the person that lodge a complaint has to do it by way of paying 200 ringgit. That is number one. Number two, he or she must make a statutory declaration and write down fill up his complaint form. Okay. Subsequently, ASDB will receive the said complaint and to decide whether this complaint has merit or not. If there is a no merit case, the ASDB shall summarily dismiss the case. Okay, throw out the case, no more. Okay, if there is a merit, the first step the ASDB will do is to write a letter to the so-called complaint lawyers and seek for a written explanation. Okay, if they accept the explanation by the lawyer, same thing, the case will be summarily dismissed. Okay, if the case warrant further investigation, what they'll do is they will appoint a disciplinary committee to hear the case. So disciplinary committee is some sort of a panel of 3 persons. Out of it, 2 will be a very senior lawyers with at least 15 to 20 years of legal standing as practitioner lah, okay? Very senior type of lawyers with no bad records and good reputation, and also 1 layman. Layman does not mean any person lah. Usually they will invite engineer, board of directors of the company, or even doctor, teacher to sit in. Okay, so 3 persons will form a DC. So take for example, if my case, because I'm from Johor, isn't it? So if I got a case in Johor, DC shall be formed in Johor State Bar itself, and I have to go to any place lah. Sometimes in that particular panelist law firm also got, but most of the time we will need to go to the Johor State Bar. There's a room there to hear disciplinary hearing. This is by DC. And subsequently, DC will need to make recommendation to ASDB. Okay? DC in Bahasa Malaysia stand for Jawatan Kuasa Tata Tertib, whereby DB stand for Lembaga Tata Tertib Peguam-Peguam. Okay? Difference, huh? Okay. So after DC had, listened to both complainants as well as the lawyer, they will find whether this case warrant any punishment, and they will write down their recommendation, either to reprimand, to fine, suspend, or strike off the lawyer. Okay. After that, their report will be evaluated by ASDB. ASDB has got their own boards of committee members. Okay, one, the what we call the chairperson, usually will be a retired judge. Normally, they will come from Court of Appeal and above. Okay, DB, after having meeting, they will choose whether to accept the recommendation of DC or not. If they accept, then they can impose final order. If they don't accept, it's also up to them. They can even impose lighter or heavier punishment. In the sense of lighter punishment, the lawyer get very lucky. He get lesser punishment. In the case of heavier punishment, normally what SDB will do is they will ask the lawyer to come to KL to give representation. That means another hearing before the disciplinary board. Explain himself. Normally, this sort of, again, you have a second hearing, this commonly apply to striking off. Your license is gone lah. Okay, that's why they call you twice. Okay. So back to our question. What recourse is open to Hamid to challenge the decision of disciplinary committee and whether he may apply for judicial review? Okay. So based on the amendment, previously no judicial review is allowed. So amendment in 2014, 2014, actually it happens 2012, but it becomes enforced in 2014, especially section 103 EA of your Legal Profession Act 1976. Okay. Hamid's ability to challenge interlocutory rulings. You see, the keywords is this one, interlocutory rulings during the course of disciplinary proceedings is restricted. Okay, it doesn't say no entirely, but restrict. Okay. So under section 103E through 2, okay, what we call the no judicial review proviso in the past, okay, is entirely removed. Okay. But you must remember, like I have told you so, isn't it? Lawyers are one of the smartest creature on earth. Why people file judicial review during disciplinary hearing? Any good guess from all of you, future lawyers? Any good guess? No guess at all.
More time to come up with a defense.
That is quite right. It's a delay tactic so that I can practice maybe another 2 years more. Then I can plan for my next career development. Because striking out, take for example, or suspension, it happens 21 days post decision of the DB. Even though you appeal the decision of the DB, after the 21 days, you still have to cease practice. That's why a lot of lawyers, not a lot, those culprits out there, they try to delay decision by interfering by way of judicial review. Okay? So section 103EA's rule 1 said that because, as I have told you earlier, DB, the lembaga tata tertib, is the final decision maker. DC is just to give recommendation and their findings. Correct? So DC itself is just making interlocutory decision. It's not going to affect the license or the so-called ultimate fate of the lawyer. So judicial review only will be allowed after the decision or order made by disciplinary board. Okay? But it doesn't mean that Hamid has no way out at all. Hamid can still write a written objection to DC's about the composition and also the jurisdiction. Okay, so this is you can do it within 14 days after being told that, okay, the DC insists the composition and also jurisdiction of the DC itself, the jawatan kuasa itself has no problem. So you can file objection. Okay. So remember, Hamid can only seek judicial review after DB has made final decision. Okay. And one more thing, section 103D, rule 4, Hamid shall be given representations to make any representation. That means to be heard during DC. Okay. If you file the judicial review at this moment of time, the whole course of action of judicial review shall be deemed to be premature. It will be off. Okay. The closest case that I can find by LexisNexis is this one. Ong Kee Kiong against Lembaga Tata Tertib Peguam. Okay. So what is your conclusion? Hamid cannot apply judicial review until DB has made its final order or decision. Okay. So after that, you will have 90 days actually, sorry, 30 days. This one is a freshly baked answer, I just did it 2 days ago. So some of it may contain typos, you just remind me whenever there's any errors. Okay. Judicial review is usually 90 days, but appeal for the decision of the DB is 30 days. Okay. And against I use the case of Ong Kee Kiong against Lembaga Tata Tertib Peguam. Okay. Question B is even tougher. They ask you to comment what are the grounds upon which a decision of the disciplinary committee may be impunged. Alamak. When I look at the question, I wish I can flip to the Bahasa Malaysia punya version to see whether the question is being drafted wrongly or not. Because clearly, the DC decision is an interlocutory decision, How do you want to impunge the decision of DC? In my personal opinion, it's a no. You cannot impunge at all. Because DC made the jawatan kuasa memberi cadangan kepada lembaga tata tertib tentang hukuman yang patut dikenakan atas peguam. Now you are telling me what kind of grounds that you can struck off the decision of the jawatan kuasa. The jawatan kuasa is not the final decision maker. What? So how? As far as I could think, I can only give my inputs based on the general principles of judicial review. Okay. As far as it is concerned, initially, judicial review is a species that been created mainly the first and very original historical purpose of judicial review is to check whether the executive or authorities that is to say the tribunal the quasi penalty punya board had done anything not according to standard operating procedure. Okay. The so-called standard operating procedure has a lot of relationship with the principle of natural justice that has two limbs. That is to say, right to a fair hearing, okay, right of audience lah. And the second one is rule against bias. You cannot have any prejudice when your members sitting and judging you at the same time. Or you cannot have any person in favor of you sitting there and judge you. That one is bias, isn't it? Okay. So as far as is it concerned, I will just talk about procedural impropriety, but I do not get any useful substance from the fact itself because merely Hamid is raising the composition is got problem. But why he said so, I don't know. So I can just give some general statement saying that if panelists have conflict of interest with Hamid, whether he like him or he dislike him. Okay. And second, Hamid was denied a fair hearing. But very to justify on this ground also because Hamid is the one that defaulted the hearing, isn't it? People asked him to come, he himself didn't turn up. But this is the best that I can do. Illegality, I don't think so, but I have nothing else to write. I don't know about you, but if I were you, I will escape this. I will just escape this question lah. Actually, DC is legal, unless it makes some decision or it makes some, it is not according to the law. But like I have told you, I do not get extra substance from these limited facts. So it's just general comments. And also one more ground here is irrationality. Okay, Wednesbury and reasonableness. But nothing here suggests that DC had done something that is not proportionate to the requirement of law. So I really don't know about this question, and I feel there's some flaws in drafting the question also because you can't challenge the decision of DC. Okay. Okay, next we will move to, the insolvency and also winding up question. Okay. Hopefully we can end by 10. Okay. After negotiating for some period of time, Alex finally secured a kopitiam franchise, Big Venti. Alex then entered into a hire purchase facility with OK Leasing Sdn Bhd for all necessary equipment to operate his cafe. It was agreed that Alex is required to pay a sum of 80,000 ringgit per month for a period of 36 months. As required under the facility, Alex has secured a guarantee and indemnity from a credit company, Serba Boleh Credit Sdn Bhd, in favor of OK Leasing Sdn Bhd. Serba Boleh Credit Sdn Bhd is a cash-rich credit company having more than 10 million cash reserve. Against his expectations and after the initial assignment, Alex Cafe failed to attract patrons and As a result, he defaulted on his monthly payment. OK Leasing Sendirian Berhad claimed that the total outstanding amount was 580,000 ringgit, including default interest and penalties. Okay. Alex then retained a professional business advisor to engage with creditors in finding ways to settle Alex's debts. Alex believed that he would be able to sell his properties to settle all his debts in full, but he needed time to do so. In the meantime, he will continue to make payments as best as he can. So, OK Leasing Sendirian Berhad commenced bankruptcy proceeding against Alex. OK Leasing Sendirian Berhad also presented a winding up petition against Serba Boleh Kredit Sendirian Berhad without any prior notice. On 15 March 2023, Alex found a copy of a bankruptcy notice in his post box. The winding up petition was left with a janitor of the main building where the office of another company, Serba Kredit Sendirian Berhad, is situated. Both Alex and Serba Boleh Kredit Sendirian Berhad seek your advice on how to oppose the proceedings commenced by OK Leasing Sendirian Berhad. So your duty is to advise them. You must, you must be familiarized with how to make a person bankrupt and how to involuntarily wind up a company. Okay? To make a person bankrupt, first, you cannot just say the person owes you money. It's not as simple as that. You must obtain a judgment from the first. And after you get the judgment, the person, the debtor, still refuse to pay. At that time, you can say that the person has committed an act of bankruptcy. After that, what you do, you issue a bankruptcy notice. This bankruptcy notice is you file in the court, then the court will seal it, then you have to serve to the person. It's not just like our normal lawyer letter, It's a formal short notice, and you serve it to the person. Okay. Whether by personal service or you cannot find the person by substituted service. After the receipt of this bankruptcy notice, the debtor has 7 days to reply by affidavit in reply. Okay, if not, the precondition under this what we call Section 3, Rule 1 of your Insolvency Act. Okay, particularly we talk about the Section I Insolvency Act, that is the of bankruptcy is committed. Then after that, debtor can actually file someone in chamber to set aside bankruptcy notice. If he doesn't do so, or he has no good grounds to set it aside because he memang tak bayar kan. So the creditor can proceed one more step. That is called creditor's petition. Okay. After that, you file this creditor petition. Petition means something like the commencement document. It's just like originating someone and also read. You must serve it within 6 months. The expiry date is same with our read lah. 6 months from the act of bankruptcy itself, you must serve to the debtor. This is also by way of personal service or justice. Subsequently, the debtor will need to show cause. Show cause means I do not owe you money, or I pay you already, or I already fulfill the debt's obligation. You have no right to get bankruptcy order, because bankruptcy itself is just like the semi-punishment. Those who were being declared bankrupt, they will not have liberty to work without the approval or sanction of Director General of Insolvency. They also cannot keep their bank account. They cannot travel. A lot of restriction in life, Okay. And subsequently, the whole creditor petition is just like a trial thing. It's just like a trial hearing. The court will decide whether to allow the bankruptcy order to be uh, ordered or not. Okay. Otherwise, the so-called the creditor's petition will be dismissed if the debtor can show that he already paid. Okay. So our task is to advise Alex how to oppose this bankruptcy order. Okay, a bankruptcy order. The what we call the bankruptcy proceedings. Okay. So number one, at the very beginning, regardless that you are dealing with winding up or bankruptcy, the first thing to be clear is the relationship of the party. Who is Alex? What is his status? Why is he has to do with the debt? Okay, see, my first argument is that the facts already provided, isn't it? Alex borrow money from Serba Boleh Credit Sendirian Berhad for his franchise cafe business. So this is a commercial purpose, isn't it? So he is not a social guarantor under the meaning of Section 5 Subrule 3 of Insolvency Act. You must remember, some facts has been provided to you for a certain reason. It's not just there for fun. Okay? So you must say he's not a social guarantor. Therefore, Serba Boleh Credit can go after him for money. So this is the position of Alex. Second thing, we look at the threshold of the debt and we look at it whether this is a final judgment or not. Okay, you see, my argument is all comes out, the debt itself more than 100,000. So nowadays, the threshold to make a person bankrupt is 100,000 ringgit. So clearly, under Section 5, Rule 1A of your Insolvency Act, it has gone beyond the threshold. Below the threshold, you cannot commence bankruptcy proceeding. So make your minds very clear, okay? So second thing, I will say because it is inclusive of default interest penalties. I don't know whether you remember this how to say 80,000 times 36 months. I have calculated it is actually less than 300,000 ringgit. I don't know why the mathematics of examiner has something wrong. I mean, default interest and penalties altogether so much, or how? How is a loan shark or what we call? I don't know. This what we call the some errors or not. But anyhow, this is the case here. Okay. Okay. So I will say because it includes of this outstanding amount, then plus default interest plus penalties, I would say this probably is challengeable. It may not be a liquidate sum. Normally, how we get a judgment, we get a sum, a final sum, In the bankruptcy notice, we would not put the default interest, we will not put the penalty charges, all that inside one. We will just put a liquidate sum. Because this is one of the requirement of law that you cannot quantify, you cannot without ascertain the amount and you put a person bankrupt. The amount itself must be highly specific. So this is provided under the case of Fauzia Osman against Bank Bhumiputra. And Alex would have only committed act of bankruptcy by virtue of Section 3 Subrule 1 Subrule I, if OK Leasing has obtained the final judgment from the court. But however, as you can see from the fact itself, it was not specifically mentioned. Okay, so if it is not a final judgment, you cannot go for bankruptcy. So udos aka rigging. Okay, then after that, you go to the service of bankruptcy notice. Okay, so under sections 3, subrule 2, and rule 95, rule 108 insolvency rules, as well as your rules of court, whatever, okay, it must be personally served to the debtor. Okay, if it is not personally served, then you cannot take effect of this you cannot commence the next step, that is your creditor petition. Okay, because the service itself is not valid, on technical ground, you can challenge, Okay. After that, you look at the date of this bankruptcy notice. He received it on 15 March 2023. Okay, this is a tricky part. So you have to frame your words. According to Rule 94 of the insolvency rule, bankruptcy notice after you extract from the court, it will only valid for 3 months. So the facts is not very clear, but you get some evidence or inputs here and there from the facts. There is a date there. So make yourself to be more analytical and critical. You should advise Alex compare when this bankruptcy notice is being issued. If it is more than 3 months, I mean, it is issued like in January 14. On the time you receive it, it's already 15th of March, more than 3 months. So the bankruptcy notice is no longer valid. So use this point here to say like that. And one more thing, application to set aside bankruptcy notice. At this stage, we have yet gone to the creditor's petition, isn't it? So how to set it out is under Rule 17, Insolvency Rules 2014. That is by summon in chambers by supported with affidavit within 7 days after the receipt of bankruptcy notice. So the ground that you can challenge is all of above lah. You query on the dispute of the liquidated sum, you dispute on the service, and you can also dispute on the validity of bankruptcy notice if there is any lah. Okay. And one more important point, at the end of the paragraph, you notice or not, Alex had been trying to engage with a professional advisor to settle his debt. Normally, this is a very good grounds to oppose the bankruptcy notice, because like I have told you earlier, bankruptcy order is a quasi-punishment. It restricted the freedom of a citizen. If that particular person has intention to pay up the debt, it means it's not mala fide. Okay. What you can do is Alex may consider voluntary arrangement as one of the options lah. Because bankruptcy order has not given yet, so you can use a lot of opportunity. You can negotiate with OK Leasing and discuss lah, sell off the property, sell off the whatever equipments in the what we call the big venti cafe, so that you can materialize the debts. Okay, so you briefly discuss to show to the examiners you know the existence of voluntary arrangement with creditors. So this is provided in sections 2A to 2Q of Insolvency Act. Okay. So subsequently, we move to how to oppose a winding up of companies. So winding up companies, you must look at two particular laws lah. One is, of course, Companies Act itself, because Sendirian Berhad, what anyhow, is governed by Companies Act 2016. And you have your companies winding up rules as well. Okay. Different from individual bankruptcy or insolvency, to put it in a nice word, to make a company to wind up, you do not need a judgment. All you need to do is to send a statutory notice of demand under Section 466 of Companies Act 2016. This so-called statutory notice of demand is just a normal lawyer letter. I repeat myself, not like the bankruptcy notice that you have to extract from the court. This notice of demand under Section 466, you can read my previous YouTube this lecture. I think I put some course paper inside. Okay, this lawyer letter, so long it comply with the 466 Section 466 requirement, is okay. Okay. Then after that, you'll be giving the debtor 21 days. The debtors means the Sendirian Berhad, 21 days to settle the what we call the payment that it defaults. If the company still adamant refuse to pay, then you can commence winding up petition after 21 days after the receipt of notice of demand by the default company. You get what I mean? 21 days post receiver by the company, then you commence the action. Then you serve the winding up petition to the company. Subsequently, you have to advertise in two local newspaper, okay, or even Gazette, to say that, oh, this company sedang digulungkan, something like that. This reason is to tell some of the creditors, because the companies may not only owe you money, it may owe other people money. So you make the news, this is like notice to others, okay? Secure creditor, preferred creditors, etc. Okay. Then there will be a hearing of winding up petition, and subsequently the court will make an order. After the order, it has nothing to do with us already. Normally, the companies will appoint whether a private liquidator or a government liquidator to charge of whatever the assets of the companies. Okay. Okay, where were we? Okay, so Serba Boleh Credit Sendirian Berhad is sued by OK Leasing for guarantee and indemnity in favor of Alex. So the ground of the winding up is actually involuntary winding up. So pursuant to Section 465 Subrule 1 Subrule E of Companies Act, that is inability to pay debts. The same is being defined also under Section 466 of Companies Act 2016. Okay. Number one, actually, this is not, wait. Where is it? Okay, number one is to, yeah, it's here. Okay. This one, by right, is the relationship of the parties, Okay. Like I have told you, you must look at the position of the company. Position of Serba Boleh. Who is Serba Boleh? And what is it? Okay. So first, you have to examine on what kind of the legality of the guarantee and indemnity. Because you must first understand it was the Big Venti Cafe, through its agent or directors or shareholder, whosoever, Alex, that borrow the money from OK Leasing Sdn Bhd, isn't it? So actually, Serba Boleh Credit Sdn Bhd did not have any consideration. It doesn't get any benefits out of this loan, correct? This is the legal position that you must clarify first, Okay. So why I said this in the first place, because you must name the right party to sue for winding up. Because otherwise, the party will dispute, why should I pay? Why you say I owe you money, isn't it? So if you are good enough, you can use section 79 and also section 81 that provides for contract of guarantee. Okay, there's such thing as a financial instrument, there is a letter of guarantee, Okay, take for example, if I'm a financial company, there is certain charge, charge of the, Big Venti cafe, or my good self some land or whatsoever, or even the proof of debts whatsoever lah. Okay, the charge open me. Then I can write a letter of guarantee to facilitate the further borrowing of money on behalf of Big Venti. That means to say, if he defaults, Alex default, or Big Venti default, I have to pay on behalf. Okay, as a financial instrument. There's something called contract of guarantee. This is provided under section 79 and also section 81. Okay, so if let's say you execute this contract of guarantee, no doubt you do not get anything, you do not get any consideration, because by standard of law, by contract law, any contract is void in the event of absence of consideration, correct? Because saya tak dapat apa-apa balasan So why should I pay? Why should Serba Boleh Credit pay? So first position, get rid of this problem first. Okay. Second, dispute of debt. Don't go straight away, because marks a lot, and there's a how to say, you have to stand out, among the best of the best. Then only they will pass you. And then second, you look at the amount of the debt. For companies to wind up, it is lower than individual, 50,000 only. Okay, as provided under section 466 sub-rule 1 sub-rule A Companies Act 2016. So section 466 1A did not actually mention the figure, but it mentioned it is decided by the minister. Who is the minister here? Minister of Finance, who is also our Prime Minister lah. Okay. So Serba Boleh may actually challenge the same ground, not liquidated sum. You must not include the what we call the penalty and also the interest. Okay, you must only put up one exact sum, 550 ringgit. Sorry, 580,000 ringgit. Okay, so there is a presumption provided with the same section 466 that the company is commercially insolvent if after you receive the letter of demand, the so-called statutory notice, 21 days you still never pay, you are deemed to be commercially insolvent. Okay, so what are the grounds here to challenge the winding up petition? Okay, see, there is no statutory notice of demand. So this one is one of the irregularity. And second thing, you must also extract from the fact that this Serba Boleh Credit Sendirian Berhad has got 10 million ringgit cash reserve. You see, cash reserve is different from asset, In order for you to be called commercially insolvent, okay, or commercially solvent, you must have enough cash flow to pay the debts. As simple as that. It's not the calculation asset minus liability. It doesn't work like that. I don't care how many lands you have, but your cash flow is broken or you cannot clear the debt within 24 days and the debt itself is more than 50,000, then the company is commercially insolvent. This is good enough already for you to have a winding up petition. Okay, very important, But this is obviously not the case of Serba Boleh because dia banyak kaya. Okay, and improper service of winding up petition. The winding up petition under Rule 25 of CWUR, you must serve it on the registered office or principal place of practice. So this one serve to where? Serve to some other place, isn't it? Where is it? I think it's not janitor. I mixed up a bit. I think serve on the other building. You see or not? Okay. Main building where the office of another company. Okay. So you do not serve to the authorized person. That one is also one issue, If you serve to your clerk with acknowledged or at the chop, the acknowledged receipt, this is different issue. But you serve to janitor, unlikely this is going to be a good service. Okay, so you can challenge on the improper service of winding up petition. And fifth, this is one of the tactic used by some creditors. We call malicious prosecution. Malicious prosecution is intentionally to file a winding up suit to kacau the company, to make their life difficult. So usually those creditors that, normally construction, it happens a lot. A Sendirian Berhad engaged B Sendirian Berhad for some M&E work, the mechanical and electrical works. So B company did a very bad job. So A company refused to pay. The total debt more than 100,000. More than 50,000, sorry. So B, because of sour relationship and all that, filed a winding up petition to kacau A Sendirian Berhad. So regardless whether they are rich or not, they just file. So this is malicious intention to abuse the court process. I think OK List in this issue has got bad intention here. Okay. So after that, what you need to do, the company must file affidavit, affidavit in opposition at least 7 days before the hearing. This one's very simple. On the credit, this winding up petition, it will mention the hearing date one. You have to file 7 days before the hearing. And also, if let's say this what we call the affidavit imposition must, according to Rule 30, you must state who are you. Usually affidavit filed by authorized director, diberi kuasa, and what are the grounds that you want to challenge it. You said that you can pay or you have paid. Okay, so this is the grounds to challenge the affidavit. Company winding up petition. And Rule 28 of your CWUR said that anyone that intend to appear the hearing must file a notice of intention to appear. Okay. So alternatively, because at the end of the day, if you can settle the debt, there will not be winding up petition. So think a little bit out of the box here. Don't just think of the technical ground. So if Serbabole here got 10 million, let's say for example, he's just clear off the 580,000. Then after that, he can first pay the debts, then he file a lawsuit against Alex lah, to claim contribution or indemnity from him. This is one way out. Okay. Alternatively, what other I mean, let's say for example, this is obviously not so applicable in Serbabole case because Serbabole is rich, isn't it? Let's say in some case the company really cannot pay, commercially insolvent. The members of the company, take for example the shareholder, the director, can actually file a fortuner injunction, okay, to stop winding up proceeding, but subjected to good faith lah. It's not simply play, around like that lah. Okay, so this is provided under Mobicon against Innis Communication case. All right. And lastly, okay, wow, 10 o'clock already. Lastly, we have to answer the probate question. Question A. Order 71, Rule 37, Sub-Rule 1 of Rules of Court provide that any person who wish to ensure that no grant is made without notice to himself may enter a caveat. Explain this procedure and process that could be employed by the person seeking to remove the said action. So, number one, what is a caveat? Caveat is to stop a grant of probate, okay, GP, or letter of administration is being ordered and granted by court without notice to them. Okay, as simple as that. Okay, so this actually happens in what we call the Order 71. Okay, Rule 37, Sub Rule 1. This is the rules of court proviso. But the main legislation is coming under Section 33 of your PAA 1959, in which the whole source of the power to allow a person to enter a caveat coming from Section 33. And this is the procedure. It's just a very simple notice. Okay. You can refer to my YouTube. I show a course paper before, an example to file a caveat. So this is my Form 164 in High Court Registry. Okay. So long it is sealed by the Timbalan Pendaftar or Penolong Kanan Pendaftar of High Court, then it is deemed to be entered. Okay. And the expiry date of this caveat will last for 6 months. Okay. So this is under Order 71, Rule 37, Sub-Rule 5, unless further caveats is lodged. Okay. So what is the effect of caveat? The effect of caveat is that no grant of probate or LA shall be issued without any notice to the caveator. Okay. So how to remove the caveat? Okay. Very simple also, but highly technical. Probate question is not so favorite question of mine as compared to insolvency and winding up, to be frank, because if you meet with this caveat citation, you have to cite Order 71, all that. And you cannot just cite a general one. You have to be very specific. Which proviso is that? So it makes your marks very difficult to get, Okay. So how to remove it? That is by Order 71, Rule 37, Rule 8. The cavator can be served a warning by the person seeking for a grant, the cavity, by using Form 165. Okay. So this warning will actually serve like a show cause letter lah, to ask the cavator to provide what is your interest in the estate of my late father, for example. What is your demand and what is your reason to enter a caveat? Something like that. Okay. And subsequently, pursuant to the section 9 of the same order, the cavator may withdraw their caveat. Okay. Or even if, let's say, the cavator failed to enter appearance within 8 days after you have the cavity issue the warning, okay, you don't enter appearance, you don't appear before usually the timbalan pendaftar of the High Court, you don't go and explain what is the reason, etc. It will be deemed to cease the effect. The caveat will be terminated. Okay, as simple as that. It's all about procedural rules. Number B, okay. Order 71, Rules 41 to 44, Rules of Court provide the procedural known as citation, explain the meaning and types of citation, as well as the procedures that must be used to apply for the citation. Again, because citation, caveat, all that is deemed to be contentious probate, So you have to use a very, very sound and solid specific provision. Then you'll be given mark. The examiners will be very keen and demanded to look at the section of the rules, So I think a bit difficult. If you just cite Order 71 and then you just give general idea, maybe they don't even grant you the pass mark. Okay. So one is actually citation. Citation is a legal process. A person is being compelled, to accept or to renounce or to take out the grant. Okay, three things. Accept, renounce the right, or take out the grant. That means normally this is for the executor in the will. Okay, or administrator of LA. You get what I'm saying? If the will name Mr. Ali to be the executor, but after the death of the deceased that named him to be the executor, he refused to do anything. He refused to go to court and he refused to perform his function as executor. Then the family members or the beneficiaries of the will be extremely unhappy, isn't it? So this is the procedural rule citation you use to force Ali to go and explain to the court why he do not execute, why he didn't perform his function as executor. Whether you want to give up that right or you want to execute it, you just tell the court so that a new person can be appointed, something like that. Okay. So the types of citation is whether to accept or refuse a grant pursuant to Order 71, Rule 42, Rule 2, Sub-Rule 1, Rules of Court. Okay. So self-explanatory, isn't it, by the the wording of this order itself. Okay. For example, if an executor named in a will is unwilling or unable to act, a citation may be issued by, like I said, normally beneficiaries is the one because they need the money urgently, rather than in the hand of executor. They feel not safe with them. So you have to do a citation to ask them, you withdraw lah, you menolak lah. Okay. So to take out a grant of probate by executor de song top. Okay. So Order 71, Rule 42, Rule 3, a beneficiary may issue a citation on an executor de song top, someone who had actually intermeddled in the estate to show cause why they should not be ordered to take a grant of probate. Okay, since you hold everything, take for example, especially the companies, we have seen this a lot because land a little bit difficult because land is usually by way of MOT, isn't it? Memorandum of transfer, whereby the operation of company, sometimes the family member who has hold some shares, who is also the beneficiaries and also executors, they will continue to run the company, but they don't want to transfer the shares of the deceased to the relevant beneficiaries. Okay, usually family dispute like that. So if you be with those so-called the company of the deceased, you run the operation, you sign the check on their behalf, etc., but you refuse to take grant of probate, but yet you are executor. So citation, you have to uh you have to you have to cite them and to take out the grant. Okay, Order 71, Rule 42. Okay, and thirdly is to propound a will. Okay, a citation to propound a will may be directed to the executor's name in the will and all person interested. Okay, usually also done by beneficiaries. Okay, if let's say the person, the citee, the one that start with or, the Tor, or is always the person that give order to provide something. It's always the or. The EE is someone the receiving end. Okay, remember the E here is end. This is how I remember lah. Okay. So the citee did not enter appearance or does not proceed to propound will, then the citor can apply for an order of grant. Okay, so these are all procedural rules. Citation may be issued in the prescribed form, and then the citation must have a affidavit in support. Then citer must enter a caveat to stop the grant of probate before issuing the citation. This one very important, I think. Okay, and the whole course paper must be served personally on the citee. Okay, and the whole thing is the will must be filed in the registry before the citation is issued. Okay, and finally we come to the last question. What are the types of grant of representations may be issued by the High Court? Okay. So in order for you to answer this question, you cannot just give grant of probate, LA, all that, finished. No, you must cite specific laws. Okay. First thing first, the High Court, if there is a present of will, valid will, and there is an executor that is willing to execute the will, the executor can actually apply to the High Court to get grant of probate. So this is pursuant to Section 3 of Probate and Administration Act 1959. The executor or executrix perempuan should apply by OS, supported with affidavit, tender with a few exhibits, evidence, okay? That is the death certificate of the will maker, the valid will, the certified true copy of the will, and also list of assets and liability pursuant to Order 71, Rule 5 of Rules of Court. Okay. Second, the High Court can grant LA in the absence of will. That means no will is there. Okay. The court can appoint any administrator. Usually, administrator is family member, and also would be the beneficiary of the whole estate of the deceased. Okay, make things very easy. So Section 30 of PAA, the Probates and Administration Act, provide the High Court can grant the power to the persons interested in the residual estate of the deceased. Very important for you to cite the specific one. Don't go and just generally, oh, no will, then the High Court can appoint anyone to distribute the estate. Like that, you get a fail mark. Okay. And how to apply? Or as by affidavits with exhibits. This will include death certificate, senarai, asset, and liabilities. Okay. Subsequently, you need to file the senarai waris as well. Okay. We have a grant of LA with will annex. Okay. Actually, LA with will annex is the case the person dies with will, but however, there is a defect in the will, or the executor die before the will maker. That means the executor is no longer exist or cannot act anymore. So this condition, the court will actually appoint an administrator who is usually the next of kin of the deceased to manage the distribution of the asset according to the will. So the main difference between LA plus will is that the distribution of the asset in this LA with will annex will be distributed according to the intention set up in the will of the deceased. But whereby in this LA alone, the assets will be distributed according to Distribution Act. Okay, as simple as that. So Section 16 PAA provides the law here. Okay, LA with will annex may be granted in the condition where there is a valid will but no executor is named or the executor is unable to act. So the application is almost similar, or as plus affidavit, then put on relevant documents. Okay. Grants de bonis grants de bonis non is the condition where the administrator or the executor had already been appointed. He has done his job halfway. Halfway means I have distributed 50% of the asset. But remaining 50%, saya tak sempat buat. Or during the distribution process, somehow rather the executor or administrator fell sick, die, or in a serious dispute with the family member, too stressed to distribute the assets because people keep scolding him. So he give up, something like that. Okay. So you see, Section 14, sub-rule 2, on the death or incapacity of executor or administrator, the administration can be granted to other person, the bonus non. This is how it comes. And Section 16 and Section 30 provides that the new appointment can place to complete the estate administration. Okay. And the new administrator should apply with what we call OS plus affidavit, but you must show different things. Here is that you have to show LA or grant of probate, list of assets that are still remain unadministered. Okay, so this is pursuant to Order 71, Rule 5, Rules of Court. All right. Okay. Oh, finally, we finished. I'll stop the recording.